All right, welcome, good evening, everyone. I hear like an echo. Yes, Dunya? No? We're okay? All right. So welcome to the Board of Adjustment meeting. Today is Wednesday, May 25th, 2016, and I'll call the meeting to order. And it's approximately 6:32. Okay? Of course. Will everyone please rise for the Pledge of Allegiance? And Mr. McDermott, why don't you lead us in the pledge today?
I pledge allegiance to the flag
Of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. May we have a roll call, please?
Rosalind Philippe,
Here.
Holly Cohen,
Here.
Michael McDermott,
Here.
Dottie Joseph, Dana McGlure-Fenelon,
Here.
Peggy Boulay. We have quorum.
Thank you. And Mr. LeBlanc, would you do the honors of explaining the process?
Thank you, and good evening, everybody, and Madam Chair. Actually, tonight, our consultant, zoning administrator, Mr. Alex David, he will be the one, leading the charge. And then I'm just here to formally introduce him, so he will take over from here.
Alex David.
David, like the first name.
Mr. David,
Yes.
welcome.
Thank you.
Uh-huh. Okay.
You want to introduce the city attorney? You were supposed to do that too.
Oh, and then
I know.
I mean, because everybody knows you're here. Also, our deputy city attorney, Mr. No,
No, no,
no,
not you.
not you, not you.
Mr. Galdos?
Mr. Galdos, is absent today, and then our new city attorney, Mr. Jeff P.H. Cazo, will be here, to with us in that meeting, to navigate us, to this application.
Okay.
Thank you.
All right. Thank you. Bunch of new faces. Go ahead, Mr.
I'm ready.
David.
Okay, so item D, I will read the quasi-judicial items statement into the record. These items may be either approved, denied, or approved with conditions. For public hearings, please be advised that the following items on the agenda are quasi-judicial in nature. The applicant or duly authorized agent for the applicant must be present. If no representative is present, the application will be tabled to the next Board of Adjustment meeting. When the petition is announced, the applicant or his/her agent shall approach the microphone and state his/her name and address for the record. Any interested party wishing to speak on any item may approach the podium after the board has opened the public hearing. Each party shall approach the microphone and state his/her name and address for the record, and shall address his/her comments to the board. Each party shall speak for not more than 3 minutes in order to provide for order and time for other interested parties to address their concerns and comments to the board.
Thank you.
Yep.
And since this is a quasi-judicial item, if our city attorney would administer the oath? Yes. To anyone wishing to,
I don't have it, but
Make it up.
make it up, just,
my note.
do you? You swear to tell the truth. Do you swear or
Swear to
affirm?
tell the truth, the whole truth, and nothing but the truth.
I do.
Yay. Improvise.
All right.
Improvise.
Any amendments to the agenda?
Madam Chair, there is one amendment, just for clarification. We have listed on the agenda that this is a new petition, the one we'll be
I
hearing
saw that.
tonight. It's
It's
actually
continued.
continued, and because it was opened at the last meeting and then tabled by Board Member Joseph.
Okay. All right. With that being said, Approval of the minutes from March 16,
So move.
Second.
moved by Mr. McDermott and seconded by Ms. Cohen.
It's
Thank
all
you.
right. Call me anything. Improvise.
All approve? All in
Yay.
approval? Aye. Okay,
Yay.
thank you. Where are we today?
Just to speak on the record, Ms. Dottie Joseph is in attendance.
Thank you. All right, so now we're 5.
Communication.
And communications?
Yes.
Communications, okay.
I spoke to Carol Keys regarding this application.
Okay, so Councilwoman Keys, okay. Yeah, there's only one.
Okay, on yesterday, I spoke to Kevin Burns regarding this. I returned his email requesting a call, and we discussed his concerns about, not his concerns, his statement as to why it was on the agenda.
Okay. Any other communications? Okay. All right, with that being said, we will start with V-3-16, which is Valvoline Instant Oil Change, 1600 Northeast 123rd Street. Is the applicant, of course, they're the only one here.
No.
Okay.
Good evening. My name is Tom Roberts, and I'm with the law firm of Raquel, Riddell, and Fernandez. We have offices at 200 South Biscayne Boulevard, Suite 850. That's Miami, Florida, 33130. And I'm the attorney representing the applicant.
Thank you. And Mr. David, you go ahead and explain.
Thank you, Madam Chair. Just for the record, this application was duly noticed in the newspaper, dated, it was published May 12th. It was also, the notice was mailed on May 12th, and the property was properly posted pursuant to the city code.
I saw the signs on the property.
And I took a picture just to make sure that. Basically, before you is, as we said, Valvoline Instant Oil Change, and the address is 1600 Northeast 23rd Street, and it's at the southeast corner of that intersection. It's now a vacant parcel of about just under a third of an acre, 13,650 square feet. And I just wanted to explain a little bit. We're here, it says a special exception. We're here to review it under a part of the special exception criteria, because that's the only mechanism to deal with this nonconformity going to a proposed new nonconformity. So basically, I just wanted to give you a very brief history of the site, and then Mr. Attorney will, the applicant's attorney will fill you in a little more. But this building goes back to about 1962 as far as we could determine, and it was a gas station since the early 1990s. As you may know, it was a gas station, auto repair, and convenience store. There's some other issues that went on. It had to be cleaned up environmentally, and the City Council on January 8th, 2013 designated it a brownfield site. And so it's been continuing on from there. The building was demolished, and there has been environmental remediation on the site. Based on the brownfield, the county, the applicant worked with the county to determine a plan for remediation. So even though there's no building, it's still a non-conforming, that non-conformity is still with the property. So it still stands today. We reviewed the comprehensive plan. It's consistent with the plan. It's, the proposal is consistent with the land development regulations. And in my report, starting on page 4, I responded to the proper code citations, dealing with special exceptions and the nonconformities. So basically, with this proposal, the proposed is more restrictive and less intensive than the existing nonconformity, which is allowed under the code. You can go from one nonconformity to another as long as it's more restrictive and less intensive. And we have found that that's the case with the proposed Valvoline instant oil change facility. It is a new building, and they will provide the building with appropriate setbacks, landscaping, and parking, so it will meet the current code. And in conclusion, I made a recommendation for approval with about 5 conditions, and they are listed on page 7 of my report. With that, I'll stop and answer any questions.
Okay. Thank you. We'll allow the applicant's attorney.
Thank you very much for the opportunity to speaking with you tonight. I wanted to point out that I have with me tonight the owners of the property, Kerry Graham and Mr. Marino. They are the actual owners of the property, and I apologize for the board.
Okay.
I also have with me Patricia Ramuto, who is the person who created the plan that we're going to see and that is part of your packet. And I also have Stan Schultz. Stan is one of the managers with Valvoline. He's an expert in the construction and the maintenance and in the operation, and he's going to speak to you for a little bit about how Valvoline operates and how they're going to be working at this particular site. We're here today to ask for a special exception. And the reason is that we've already gone through the process to make a determination that this is a lawfully existing non-conforming use that we are entitled to continue. And having made that determination, and that determination not having been appealed by anybody, it is final. And so we are here solely for the purpose of seeking a special exception which is provided for by the city's code. That special exception is controlled by section 6-702 of the code. What that says, and it's specific to eliminating non-conforming uses, says that in order to have a non-conforming use eliminated, you have to do one of 3 different criteria. Those 3 criteria are a significant upgrading of the property, the building facade is what it actually says, additional landscaping, or, and I point out to you the code says or, but as I'm going to show you, we meet all of them, upgrade or improve the parking. And so what I intend to show you in the next few minutes is that not only do we comply with one of these, we comply with all 3 of them. And as I think your city attorney would tell you if you were to ask him, in a situation of a special exception, if the applicant can prove that they meet all the legal requirements of the special exception, they are entitled to it. It's not a discretionary, it's not unlike a variance, it's unlike a zone change. In a special exception, if you meet the legal requirements, it's an entitlement. And so I hope that through the course of this I'm going to show you that in fact we meet all 3, not just one as it should be done, and that therefore we should be entitled to the special exception. What existed there before was a 1962 gas station that also did major mechanical repairs, also did gasoline, and that over the course of its life did substantial contamination to the property. My clients, at a substantial risk to themselves, took on this piece of property, and they have done over $500,000 worth of cleanup in order to get this property to a point where it can be used again. And right now they're not even finished with that. DERM, which is the Department of Environmental Resources Management, still has certain things that they are required to do before they can get what's called the no further action. And so that number will go up before they have the opportunity to even start this project. And that cleanup has been the reason why it has sat vacant for as long as it has. They needed to, in any instance where there's a gasoline station with historical contamination, and in this particular instance, the gas station had tanks that had been out of date since 2009. So when they took it over in 2014, it was mandated by the state that those tanks had to be removed, that of the time of the removal, there has to be an assessment done, and because contamination had been done prior to that, the assessment had already been partially done, and so they knew there was contamination. My clients knew there were contamination when they took on this property. They knew they were going to be facing a substantial cleanup, but they thought that they could do a redevelopment that would be, first of all, a real improvement for the city, provide jobs for the city, and at the same time, be a service to the community. We think that this is in fact meeting them. What was it like before? I apologize for not having my easel with me, but the last time I was here, there were 5 easels, and so I didn't bring mine this time. And so I apologize for doing this kind of Vanna Whitish. This is a photograph of the property that was taken after my client had actually started work on the property. You can see that all the pavement's missing, but they've not yet demolished the buildings. So there has been substantial cleanup already occurred. At this point, the tanks have already been removed. But there's contamination underneath these buildings at the time when this picture is taken. This is a photograph of the building immediately after it ceased operation. This is like 4 days after it ceased operation. As you can see, it's a pretty beat up old building. There's little or no landscaping. That tree happens to be a Norfolk pine, which is on Durham's list of prohibited species. What you see back here that looks like a pipe is from an old cleanup that the state did in the 1990s that they just left the equipment sitting there. There was a cleanup program that the state ran, and it wasn't worthwhile to actually go retrieve the equipment when they turned it off. And so that's from the 1990s when they did a groundwater cleanup. So the property was in pretty bad shape. I want to point out to you what the intensity of the use was. This is a picture of the garage bay where it was operated. You can see he's got one thing up on the rack. This particular type of lift requires hydraulic motors and hydraulic oil that's all underground, and that was part of the contamination. You can see that there's tools strewn about. It's very disorganized, and they were doing major automotive repairs at this site. That level of use will never be at this property again if this is passed. Fine. I have one more that I want to show you. Now this is an aerial of the property. And the purpose for bringing of the property as it existed. And I want you to notice that no landscaping. There is no landscaping other than the one tree that's an exotic species and some shrubs that have grown up back here that are similarly exotic. There's no parking. There is not a single marked parking lot space on this picture. So this facility, as it existed, this building would not meet current setbacks. This setup, this entire layout, would not meet today's code. So why am I showing you this? The 3 criteria are a comparison of the old to the new. What we are proposing is a Valvoline. This is a representative building. This is going to be a 4-bay, according to the plans that we have. And this is represented, this is actually one that was built in the past year. This is what they look like. Can there be minor modifications? Of course. But this is what we're proposing to put up there. This building is a substantial improvement over what was there before. I also have the proposed site plan and landscaping plan. what I want to point out to you is with a building that had no landscaping, we are going to be, and required by current city code, to be doing a substantial amount of landscaping. This is in your packet. You will see from looking at it that there's a requirement of a total of 343 different plants. Some of those large trees, some of those medium trees, many of those shrubs and bushes. But compared to what is out there before, we're doing a substantial improvement in the landscaping. You'll notice that it's got properly marked parking spaces. Again, required by your code, so that this building, once it's built and once it's in place, will comply exactly with your code for both parking, landscaping, all setback requirements. It will be completely code compliant once it's presented. And so you can see from this that not only is it a substantial improvement from a visual standpoint from the old building, it's a substantial improvement in the landscaping and a substantial improvement in the parking. It's also required to have full compliance with DERMS regulations, the state's regulations, which of course didn't exist when 1962, when the original gas station was built. Importantly though, this use is a substantial reduction in the intensity of the use that was there and which is frankly authorized there. Based on the fact that it is a legal non-conforming use that we are entitled to continue, we could actually put back what was there before. Major automotive, gasoline, convenience store, but that is not what we are asking for. We are asking for a substantial reduction in that, and I'm going to ask Mr. Schultz to please come up and discuss with you the operation of a Valvoline so that you understand how they work.
I'm Stan Schultz. Excuse me. I'm the facilities manager for Surfside Lube, which is Valvoline Instant Oil Change. We have approximately 66 stores in our chain, and we're looking to expand coming into the southern Florida area. What a lot of people have a problem with and don't understand is a Valvoline Instant Oil Change is not. There are no repairs made in these businesses. It's strictly a preventative maintenance program. Fluids exchanged, air filters, oil filters, transmission fluids, those kinds of things. There is never mechanic work done. There's never a car left on the lot overnight. And in most cases, the state of Florida has talked about even changing our classification from minor automobile repair, because we're not, to a retail sales type business. We have a waiting area. We try to keep people in their car, pull in. We have a full basement underneath these buildings, and we have a pit man downstairs that actually drains the oil and puts the filters on. And then we have also a person upstairs doing this work. So that's what makes it a 10, 15-minute oil change, where you drive in, get your oil changed, and drive straight out. We have a waiting area. People like to get out of their cars, but again, we try to discourage it. We hire employees, local employees. We don't bring people in. We have one area manager that takes care. Right now, we're in West Palm Beach and north, and one area manager that takes care of the whole area, but we have a store manager, and we'll have somewhere in the neighborhood of 6 to 8 employees, depending on the volume of the store. We don't have contamination problems. We have our oil is picked up, our oil is monitored, and we have no floor drains, no sump pump system that oil can get out of the building in case there is a spill. It has secondary containment. There's no chance for contamination unless it's done intentionally by an employee. That's basically the minor situations of how the buildings operate. Is there any questions?
Madam Chair, I do have a question.
Mr. Schultz, could you talk to them about the maintenance and upkeep of the buildings that Valvoline does?
Oh, well, as far as the landscaping, they hire landscaping maintenance people to take care of it. They have a maintenance, they have 2 maintenance people in the state that are constantly coming to stores to do any repairs and upkeeps that are needed.
What kind of training does Valvoline give to its local employees?
Okay, Valvoline Corporate has a computer training program that the employees, once they're hired, train in the store on the computer in their off times when there's no vehicles coming through, and they are graded and established that they have to complete these programs in a timely manner, and their pay is increased.
During the
these
startup, how would they go about training the manager?
They'll probably bring a manager in, or they will take a manager from here and go to one of our other stores and train him there and bring him back down here.
Okay, the manager that comes in wouldn't be to stay here, would he?
No, they want local people in the area.
I hear the question, but I'd like to entertain the public first. Anyone for or against this item who would like to speak in addition to our 2 presenters? None? Okay. Public? Thank you. Public hearing. Oh my gosh. I have been my mind lately. Excuse me. Ms. Joseph, you did. I did. Public hearing is closed.
You mentioned that there's a full basement underneath
Yes, ma'am.
most of the time, and I know the water table here in South Florida is a little bit different than throughout the rest of the state. Have you done some studies to evaluate the impact of that
Yes.
with regard to a full basement?
Yes,
And it's still feasible?
no problem.
Have you had to make any modifications?
No.
What are the
I've done
dimensions?
these for 20 years.
No, that's fine. I'm just asking because I'm not familiar with it. What are the dimensions, more specifically height-wise, of this purported basement that would go below ground?
The basement below ground is 7 foot 6 inches. We put in a well point system. We pull the water down. We run it. We get permits to run it through the storm sewer. It takes, for the first couple of days, we'll be pumping about 400 gallons a minute, and after that, it goes down to like 5 gallons a minute.
Okay.
Okay,
That's during construction, right?
during construction for 3 weeks only. Okay, and then once the basement is built, then you backfill it and you take the pumps out.
Okay, and how much room are you working with? How much,
7
land
foot
is there?
6 inches.
No, not your facility, like how much are you digging into, or is that already there?
How much am I digging into it?
Yes, the land
Well,
underneath?
From the finished floor grade elevation will be approximately 9 feet.
Okay. And how far are you from the water table?
I think water table is probably 4 feet right now. I think the last I heard.
It's 4 feet deep?
Right.
Okay, so you'll be in the water table?
Yes, ma'am.
Okay.
Any other board questions?
Yes.
Ms. Cole?
Okay, I see that there's a whole lot being said about having it a better use, prettier, whatever. But you glide over the fact of the cease of operation more than 180 days. I don't know, I guess I should be talking to you. Whoops, wait, hold on, I gotta roll over. Okay. And I understand that it's a better use than it actually was in the past. However, once it ceases being used for that purpose and it is terminated over 180 days, you're not supposed to be able to grandfather in this particular type of activity, because if you look at the actual zoning that this property has, it's not even allowed. It's not even considered to be discussed. And when I look at your dates here, you foreclosed, you say that the gas station was closed on March 14th. Then you go and you say legal title was obtained August 5th. That's 5 months. And then if you go from September 24th to 2015, where you actually do the demolition, which would supposedly foreclose the timetable, you don't then make an application until March 1st, which is an additional 6 months. So it seems to me, from everything I've read here, the termination has been more and greater than the 180 days required under the law that it's concerning the termination of non-conforming use. Can someone explain that to me? Why is it that, yes, it's a nicer piece of property, but when you made your original application to the council, you made an application in order to get brownfield designation that you were going to look at banks or buildings and stuff like that, and I'm looking at it right here. So my question really is, okay, Valvoline is a nice, structure someplace else. Why is it that we are really, and maybe I should be asking you, why is it that we are going beyond the 180 days in order to allow this?
Simple question. If you refer to
Simple
page 4 of the
No,
report,
Okay, let me tell you, I read that case.
Okay.
I read it from start to finish. It's not the same set of facts. They closed the hotel,
Mhm.
they renovated it, it was more than 180 days, but then they reopened it, okay? It was a different set of facts. Here, not only did they renovate under those terms, but now there's no structure. So we're looking at a year that's been vacant, and now we're giving them even additional time in which to build it. It's not the same set of facts. And if you shepherdized it, it isn't the same set of facts. So I don't understand why it is that we're bending over backwards to put in a Valvoline in an area that supposedly is going to be the entranceway to our city after people get off of a train that is supposed to be 3 blocks away. And we have an area designated for this type of thing. So I'm a little perturbed in this, that I'm sitting here reading this to give them something that's not applicable.
okay.
Well, whoever wants to answer my question.
Okay, let me try and answer them
Okay.
in an order. First of all, the case stands for the proposition that unless the termination is based on abandonment, in other words, an intent to terminate and abandon the use, doesn't occur. And so in a situation like this, where the termination was forced by the contamination cleanup, regardless of the fact that it took X number of days to get the people out there, and your timeline is quite a bit off.
I'm reading it.
The property operated until March, but based on your own city code, as long as there is a sign up there, it's deemed operating. And so when my client took possession in late August, it's still deemed operating because the signs are still up. I can show you the picture that I just showed you where the sign is
So-
up even after we've done work. So by your own code, it's deemed to be in operation if there's a sign up. My client has, prior to the date of getting this, long before they had an obligation, legal obligation, to do it, they signed a contract with the state to conduct the cleanup back in
I-
February of 2013. And so, in terms of the legality, there's never been an intent to abandon this use.
I beg to disagree, and I'll tell you why. Because when you requested the brownfield, you specifically stated there was going to be a bank, an office, or something of that. And you did not tell the council people at that time that you were going to go for a Valvoline or a gas station. So your intent at one point can't be changed to show an intent of a later date, when in fact you went in front of the board members saying that it was going to be an office building, a bank, preferably a bank, as I remember reading it, and that's your intent. If your intent changed since then, I'm sorry, that was your intent, and that's why I beg to differ. If you didn't have it in here and you had told them at that point, I would say, okay.
Well, Ms. Cohen, if I might,
Okay, you may.
that issue has been determined.
By whom?
The city. The city issued a zoning verification letter, which is contained in your packet, where they made a determination that this is a legal, non-conforming use that is entitled to move forward. And they investigated this entire timeline, they investigated all of it, and that determination made by the zoning department is binding, it's final. Right now before you, in front of this board, is you must accept that it is a non-conforming, lawful use that my client is entitled to have, and the only question that you are being asked is, does it meet the criteria necessary for a special exception? And as I think your city attorney will tell you.
Well, that's what I'm just about to ask. Is that true?
So, I went through this package, because obviously, Roland's not here, so I went through the whole package myself. Really, the criteria, that you're being asked to look at is, under section 6-702, which are the three things, whether the facade is, has been substantially upgraded, whether landscape, has been added, and whether we have parking, and it's as the applicant said, it's not all three, it's one or the other. I know that there's been discussion about the brownfield application. My opinion is anything that happened during that brownfield application, that's a state process that they came to the city for, and they made some representations. I reviewed that. There's language in there that can be interpreted as being commercial. It doesn't say that we're absolutely going to put a bank there. It says we intend to. But anyway, at any rate, that issue of what the brownfield application says, there's a procedure in the state statute that deals with misrepresentations at the brownfield application. So if we're dealing with that, one, that's not an issue for this body to decide, and two, if it is decided by the council, which I believe is the actual body that would make that decision, then they can make a decision to go and complain about that at the state level. But that's not before us here today. Before us here today are those three things that are under section 6-702. In terms of whether whether it was ever abandoned, I reviewed the case law. I looked at the timeline. Roland looked at the timeline, and based on, I had some concerns because the linchpin to their argument is the sign issue. I can't say that I like it, but that's what our code says, and it's binding on us. I saw the signs. Can we argue that the signs are not the signs we meant, that it's not an actual sign of a gas station? Maybe, but again, that's going to be something that'll have to be decided in court, and I'm not willing to take us there. So really, we're bound by what the code says. So as long as the sign was on the property, and the property was intended to be used as a automotive use, that's really what we have to go by. So. Unfortunately or fortunately for them, that's what our code says. As long as and the interesting thing, it's under the business tax receipt section of the code. So it may not feel comfortable, but that's what our code says. And so that's basically our interpretation of the code, is that they're right in terms of the sign. If the council wishes to change that in the future, they may. But for today, we're bound by the fact that they had signs on there that showed that it was going to be an automotive use, and we're bound by that.
Ms. Cohen, if I might, this might alleviate some of your concern. When they came to the board for the original brownfield, they didn't have anybody signed up for a lease, because until you have a clear path to being able to use the property, nobody signs a letter of intent, nobody signs a lease with you. And at that point, my clients were in discussions with Valvoline, with Chase, and they came here and they actually did a presentation because they had just completed a project in Sun City with Chase. And frankly, I suspect that they would have preferred to do another one with Chase because it's a known entity they've done a deal with before. But they were dealing with Chase, they were dealing with Valvoline, They even approached BB&T, which is right next door, to see if BB&T would be willing to move to that corner, to take over that corner, and they were not. So was there, and I don't think that you're going to find that there was any shenanigans here. At a point in time when they came and asked for the brownfields, they don't have a clear path to a lease. They can't sign a lease. They can't sign letters of intent. And so they were dealing with multiple potential purchasers, tenants. One of them was Valvoline. And so there was a clear intent that that was a use they intended to make of it. Had they been able to get a bank to do it, they might have shifted to that. It was that's at the very early speculative part of this. These gentlemen took a risk of $500,000 to clean up and improve a corner in the city. They have put out a lot of money. I mean, I couldn't do it. They have spent a lot of time. They, unfortunately, at the very start of their discussions with Valvoline, didn't call someone like me and say, look at the zoning and see if I can do that. It happened to be, frankly, that when Valvoline walked in, sent their engineers in to start pulling permits, they got told. And that's when this process got started to come here. And we started with the zoning verification letter. There has been a clear intent through all of this that this was going to possibly and probably be a Valvoline. And when the others backed out, it became absolutely a Valvoline. But they've done their best to try and bring into this city something that is a big improvement. You know, that corner needed to be improved. That corner needed somebody who was willing to risk a lot of money, because most people won't take contaminated sites. Very few investors, developers are willing to take a contaminated site. And it was only because they'd done a project like this before and it had worked that they were willing to take another risk here. And that other project happened to be a Chase Bank, and so that's what they showed, was the prior project to show, here's what we can do for you. And so, yes, they talked about banking, but at the same time, because at that early stage it's highly speculative, it's very difficult to get a tenant to sign on at that point. In fact, it's impossible. They were talking with a bunch of people, and one of those was Valvoline. And the Valvoline one is the one that said, yes, we want to do it, yes, we're going to come in, and frankly, has waited through this process. I mean, I think it's pretty impressive that Valvoline hasn't said to them, you didn't deliver the property when you were supposed to. And so here we are. If you say no, you know, you're telling these gentlemen who spent $500,000 to come clean up city property within the city, it's not city property, obviously, have risked their time, their money, their energy to try to do something that substantially improves what's on that corner. They made attempts to discuss it with other possible tenants, and this is where, you know, this is where the market force put it. To say to them, no, you can't do it, is to, frankly, tell other people, don't come into the city and be willing to expend money on a chance. That's what they did. They took a chance on the city of North Miami. They took a chance on that piece of property that, because it had worked for them before in other friendly cities, they thought they would try it here.
Madam
Any
Chair, I have
other-
another question.
Go ahead.
Okay, just to be clear, I'm looking at the landscape plan right now, and this might be a question for your client. So the record's clear, what's the current landscape situation like prior to implementing your landscape plans?
There was the one tree, Norfolk pine, an illegal species in Dade County. The reason is it has a very shallow root system it goes over in hurricanes. The parking situation, there was none. And the building is obviously, the 1962 building was an eyesore. It was in the wrong place for the property. It doesn't meet any of the current codes in terms of setbacks. Right now, based on the city's determination, my client has the right to build a gas station with a major automotive repair facility on that site. He just has to put the building where the old building was. And he's entitled to do that. It wouldn't matter that it violates setbacks. It doesn't matter that it doesn't meet the current city code. He wouldn't have to do any more parking or anything of that nature. He would be entitled to put a gas station right there, which I don't think anybody wants, and my client frankly doesn't want to do.
Okay, and my last ancillary question, is there any documentation within what was provided that shows how your client plans to preserve basically the water table that the basement will be sitting in?
Durham, first of all, has major requirements, but Mr. Schultz can explain it better, but you actually seal. You seal interior and exterior of the building where it extends below. It's like an upside-down swimming pool.
Okay, just for the record, would it be okay to have him say that?
Sure.
Thank you.
When the basement's built, you put a waterproofing underneath the slab and up the walls. And these basements, a lot of them that I build, water is 6 or 7 feet up on the sides of the building when the building is open and in operation, and none of them leak
Okay. And
because of
barring,
that.
and barring any intentional, as you stated earlier, activities from any employee, you have not had any instances where there was leakage or anything else infiltrating into a water table?
No, ma'am. It
Okay.
can't happen. If water can't get in, it can't get out.
Thank you.
Mr. McDermott.
Okay.
I do
Oh,
have a
Ms.
question.
Fenelon.
Yeah, thank you.
Ladies first.
You did mention, that they're still working on the cleanup. What further has to be done?
The most recent thing that occurred is they were trying to get a closure without conditions. And Durham did an evaluation of the soil out there, made a determination that there are some petroleum contaminants in the actual soil. As a result, they wanted to do additional testing of the soil. They were requesting additional remediation of the soil, and then based upon whatever route the decision is made, if they're willing to do a closure with conditions, it should be very soon that a closure does actually occur. The question is going to be whether they're going to do additional cleanup or whether it needs to be with conditions, the nature of the conditions being that they wouldn't be able to pull groundwater from the ground. They would have to have impervious surface that covers, and then they would have what are called institutional controls, meaning they would file a covenant saying that there is still some contaminant remaining there. Probably there is no real contamination there. Just based on my experience, what happens is when you take out asphalt is a petroleum. And so when you put back the dirt, there's a little bit of asphalt still in it. And so if you take that dirt and you do a test on it, it shows petroleum contamination because the asphalt had petroleum in it. And so right now they're at the point where there's petroleum contamination in very, very low levels, very near the surface, and most likely because there's some mix-in of asphalt with what's on the surface. But that should be taken care of, and they'd be ready to get a closure almost immediately.
Any other questions?
I did have one more question. Maybe I'm not sure if it's for you, but the gentleman mentioned that there's no chance of contamination in regards to disposal of oil. I guess I just wanted to hear a little bit more. He talked about some secondary containment, and I just wanted to get further clarification on that.
All of the bulk oil tanks that have used oil and have new oil are all located in the basement area. Okay, so how the DEP calls that secondary containment is the metal container that they're in is a containment, and the basement is a secondary containment. And when there's no floor drains, or in a lot of cases they used to put sump pumps to pump the water out of the building from the basement, but there are no sump pumps, there are no floor drains, there is no way for any contaminants to get out of the building if there's a spill, if a tank ruptures, or anything like that.
If I might, real quickly. By state and Durham rules, they're required to have secondary containment for any bulk product that is at least 110% of the volume. What that means is if they've got a tank that's designed to hold 300 gallons, it has to hold 500. Excuse me, 330. I didn't calculate that real good, did I? And in a used oil situation, most of the time you are substantially below that. So it has the capability to contain much more than what's likely to be in there. Additionally, any new product that they have that is being stored needs to be on a secondary containment. What do they do for that? Generally, they do pallets that are designed as secondary containment pallets. So there are methods by which there is, even if you have something that ruptures or breaks, it's fully contained. And the building and the things that are there are designed to contain it. And this is all required by DERM when they're trying to get their approval of their permits. Those permits will have to go to DERM. DERM will review what they're going to be having there, and they have to approve everything that comes through there.
And one last question is that the basement itself, how long is this basement going to be, or this containment unit, is it going to be, I guess, impenetrable for? Because we had an issue before where we had tanks that were outdated, and they weren't, and so that's where contamination began. So is there a possibility, like how long are these going to last for, and is there going to be chance of contamination later?
Understand that there's a distinction between what's called an above-ground storage tank and a below-ground storage tank. While these will be physically below ground, they are actually considered to be above ground because they are standing up. You can see them. They're not going to be dug into the ground themselves. Somebody will be able to actually look at them. Where you get contamination problems with underground tanks is nobody can see. In this instance, if a leak developed, highly unlikely, and if the leak developed such that it went through the secondary containment portion also, this is a double-walled tank, somebody'd see it. And so the likelihood of a large escape, and that's where your gasoline problems occurred, was that they're underground, nobody saw them, they would deteriorate, they'd leak. In the early 60s, nobody kept inventory, nobody would drop in and see how much, frankly, gas was so cheap they didn't care if they lost a little. The result today, though, is that because the tank is visible, it's considered an above-ground tank even though it's used in underground in the basement, because it is physically visible. You can see the whole thing. And so you don't get those kinds of large spills, because those were slow, very slow over time based on nobody able to see anything. In this instance, if you had something, it'd be immediately noticed and immediately corrected, and you'd have a very minor cleanup, just, use some water, throw down a little bit of kitty litter and pick it up. Am I correct in describing that? Okay.
Right. Mr. McDermott, we'll take your questions.
If I could, we have a consultant here, Mr. Burns, who would like to speak with you for just a moment, if you could.
Thank you, Kevin Burns, legally represented this entity. Just want to touch upon what's before you. It's a special exception. Your city attorney, your city staff has already told you that they are entitled and should be accommodated for this redevelopment of this piece of property. When I rewrote the code to allow, when I was mayor, when we rewrote their code through the previous comp plan and the LDRs, is we wanted non-conforming uses. You couldn't just go there and get rid of them. And non-conforming, when this gas station was built, it conformed. It was what was the standard. And there's hundreds of buildings in this city that are non-conforming. It's not just one or two. But we put a mechanism in that, okay, you start easing it down, start stepping it down. If you want to less intensity, and that's what's happening here. You're taking a piece of property that could legally now have a 24-hour 7-Eleven, convenience store, and gas station, taking it down to a 4-bay quick oil change location, a $2 million investment in North Miami on this piece of property that was a shameful looking property. And the way it got there is some of the fault of the city, some of the city leaders, maybe even me included, because there's a tragedy on that property. The previous owner got shot there and was paralyzed. In the city, we did all kinds of stuff to help them survive. Nobody had wanted to go there and cite them for the lack conditions that were going on there, especially after going through a traumatic event. And so partially we allowed it, the city allowed it, year after year, not to do landscaping, not to asphalt the parking lot, not to maintain it the way it should be. So part of the fault was on our own that we allowed a facility to get that bad. The city knew that was contaminated for 20 years. Now you have the city with new codes trying to lessen the impact of as we move forward, because people are moving in the city, and so the intensity is much less on this. At hours of operation, I believe it's like 8 a.m. to 6 p.m. Sure beats a 24-hour 7-Eleven or a Speedway or a Raceway. It's going to create local jobs. But we're not here to talk all about that. We're here that they're actually allowed to do it. They could rebuild the exact same building, the exact same footprint if they wanted to, and they would not even be appearing before you. But because they're relocating the building, and it's a little bit of a different configuration, that's why they're here. Folks, we have council people traveling all over the country. We have them traveling out of the country, trying to attract businesses to North Miami. How great we are. Yet you have, just in this one particular incident, individuals that have invested or close to $2 million worth of investment in this community. It's nice to spend other people's money and nice to say that it should be this, it should be that, but this is a legally permitted use. Your city attorney, your city staff has again said that. Speaking about, and I've heard this over the last few months speaking to people in the community, well, this is our grand entrance to our city. Folks, 16th Avenue and 123rd Street is not the grand entrance to North Miami. I assure you of that. Does this building look much nicer than what was there before? Absolutely. If you look over at Bay Harbor, they're doing $10 million worth of renovation work on their causeway. They did away with their toll plaza. They're rebuilding the bridge. And what is sitting smack in the middle of Bay Harbor, one of the most expensive communities in South Florida now, is a full-service gas station, convenience store, 20-hour-a-day gas station going into their community that has a much larger tax base than North Miami, that has this grand causeway. So I don't know who's people who are claiming to self-appoint that 16th Avenue, 123rd Street is the grand entrance, but as of right now, that isn't. I know we did a urban study, and we're trying to designate the entrance to downtown as Northeast 10th Avenue on the east and the canal on the west, and we're trying to really focus into downtown North Miami. But how many people or how many investors do you think are going to come into North Miami and invest their money if we continue to make it difficult when something is legally permitted, a new investment in this community? How many people are going to continue to come and pound their heads against the city? Look what's happening in North Miami Beach. The excitement that they're going through up there, and Ms. Joseph, you're in the heart of that city, and it's exciting what they're doing, and the redevelopment, and the come and build responsibly, and we'll work with you. This is a responsible repurpose, reuse of this property. It is 100 times better than what was there before. It's going to employ people. It's a pretty building. It may not be what you want or I want, but it's what the people who own the property invested. It is what legally is permitted, and it is, again, maybe 5 years, 10 years from now, somebody will come and want to build a 20-story office building there, but as of right now, this is there. And I think it's a great use. I think it's compatible with the neighborhood. Maybe we can influence across the street the Valero's across the street to re-landscape their property, to upgrade that property so that those facilities are nicer. Maybe this will spur some of the redevelopment just in that neighborhood. You know what? So let's see, let's encourage the redevelopment, not just on 16th Avenue, but throughout the whole city. And again, they're not asking for something that they're not legally entitled to. Thank you very much.
Thank you. Were you through, Mr. McCormick?
Oh, yeah. Yeah, I forgot what I was going to say. Anyway, Ms. Joseph actually proposed one of my questions in reference to the environmental. And I think that that's very important, but we seem to have that resolved. I just want to get somebody to reiterate for me, there is going to be no auto repairs on this. This is strictly going to be an oil change facility. There's not going to be any fixing of cars in the parking lot, or somebody has a side business that's jacking them up in the, that kind of thing going on.
One of the conditions that your administrator has recommended is that the owner provide a covenant that they will never return to this type of use. And the owner is quite satisfied with providing that covenant, and that there will be no major automobile repairs. It will be
Okay.
just what is currently done at a Valvoline Speedy Oil.
Okay.
Madam Chair, if I may, it might be a good time for us to read what those conditions are, because a lot of discussions are taking place are addressed in the conditions. So
Okay.
if you may.
I still have more questions, though. No, go ahead. No,
Well,
go
no,
ahead.
whenever you're ready,
No,
I'll
no,
read
go
the-
ahead.
Oh, okay.
I'll ask after.
Again, I'm sorry? Okay, staff recommends to the board approval of the requested special exception to terminate the auto service station use and allow a less intensive, more restrictive non-conforming use. With that, I'm recommending several conditions. Okay, so approval subject to the conditions as follows: that a site plan shall be submitted to and meet with the approval of the city's Development Review Committee prior to submittal of an application for building permit. Said plan to include, among other things, location of structures, the types, sizes, and locations of signage, landscaping materials, off-street parking areas, lighting fixtures, etc. So they do have to go through the DRC process. That the use comply with all applicable requirements of the Division of Environmental and Regulatory Management of the county's Department of Regulatory and Economic Resources and all other county and state agencies. That the current or any future property owner through a declaration of restrictions or other legal document shall not be permitted in perpetuity to return to a gas station, auto repair, convenience store use. That a certificate of use from the Community Development and Planning Department be only issued upon compliance with all terms and conditions of this approval, the same subject to a cancellation upon violation of any of the conditions herein listed. The last condition recommended is that the proposed oil change facility not produce impacts detrimental to or become a hazard to residents and shall be conducted entirely within the enclosed building.
Okay. Can I?
Further question? Go ahead.
Further question. Counsel, first off, nice presentation, even without the easels. I noticed that the cars coming in come off of 16th Avenue,
Yes, sir.
and then they exit onto 16th Avenue.
Yes, sir.
Okay? I notice in counting the parking spaces on this little here?
Yes, sir.
This little survey, that there's only 8 parking spaces. And I assume if you have 6 employees, those 6 employees would be taking up those parking spaces. Now, I understand that this is a transitory business where people come and go. What if 30 people showed up at the same time for an oil change? I'm about to get an answer, I think. Go ahead.
Actually, before he answers, the reason I asked that the conditions be read
Yeah.
is, as you can see in condition number 1, all of this will be decided at DRC. That's again not an issue before this board.
Okay.
So he may have drawings here, and that's commendable if they have those here, but they're not even required to show at this point. So questions about parking, the facade, any of that stuff is not really at issue here. Obviously, you can ask, and it's your meeting, but I just want you to make sure whatever decision you make is not based on on the issues that you're
Okay.
bringing up here.
The
All right.
final building
Um,
plans will have to comply with the city code with respect to the nature of the use and the number of parking. If
Right.
that is 8, then it's 8, if it's 10, if it's whatever the requirement of the code is, they must comply with it.
Okay. All right, Madam Chairman?
And no one will stay if they have to wait after
Right.
30, 29 people.
Okay.
Kind of gets rid of
Madam-
the,
It's like Jiffy Lube. Oops,
yeah, the-
sorry.
Ma-
That's your competitor.
it's not speedy oil change if you gotta wait for 2
Yeah.
hours.
Madam Chairman?
Uh,
All
go
all
ahead.
that being said, and with it's obvious that they've met the criteria, and are entitled to build this facility, I'd like to move that we approve the application.
Okay, we have a motion made by Mr. McDermott. Do we have a second?
I'll second it.
Okay, seconded by Ms. Fenelon. All right, roll call, please. Any further discussion? I'm sorry, in case. Okay, we're good. Roll call.
Rosalind Philippe,
Yes.
Ms. Holly Cohen,
I'm so
Flip the
torn.
coin.
Can I abstain? No. Then, no, but it'll pass anyway.
all right, Mr. McDermott,
Yes.
Ms. Joseph,
Based on section 76702, yes.
and Ms. McGuire-Fenelon.
Be the attorney.
Ms. Fenelon.
I think that was Maglore Fenelon. Did you say that?
McGuire-Fenelon, I'm
Okay.
sorry.
No, no problem.
Go with the,
Yes.
the easiest one.
Pick the one you want.
Okay, so, it's been approved by this board.
Thank you very much for your consideration and time.
I'm glad you got to present. Okay, now, any old business? Beside, okay, new business beside Mr. David joining our board? Welcome.
I just want to point to the board that the city comprehensive plan has been adopted by, the second reading for the city comprehensive plan has been adopted by the city council, and it is at the state level for their final review. Could they have issue on ORC report, which is objection, recommendation, report and comments, recommendation and comments, and we address all those comments and send it back to the state. So by June 23rd, we should receive
Yeah,
a
but,
notice of intent from the state stating that, our comprehensive is in compliance. Immediately following that, we will have to update the LDRs and then to implement those new policies.
There's a lot of things we need to update.
Yeah, and then so I'm saying this, because, you deal with the special exception,
Yeah.
with the variances. I mean, there will be workshops, and then you guys will be very involved in that process, so I'm just letting you know. And we're actually working on the RFP now to send that out to recruit a legal firm to rewrite the LDR for us. So, but there will be workshops, and then you will be invited.
Okay.
All right, thank you. Okay, anything else? All right, motion to adjourn?
Move to adjourn.
Second.
Okay, wonderful.
Thank you very much.
Adjourn.